Hello. Hey, y'all. I'm hoping this works better. I restarted the router yesterday. I didn't get a notification about craziness with StreamYard and internet. So I'm hoping everything is working. Hello, Henrietta. Hello, Colorado Canadian. Texas, you do your carpet. Rob, just do what you need to do. I'm here. So, obviously, welcome. I am Ducky, and we are going to attempt to do what we were going to do yesterday. And so that is go over the motion to compel and the hearing that they had because of Gingras's motion to compel. So that is mainly what we're going to do. But first, what I was going to start off with was the blog where Gingras admits that he has already lost in some part, and then one is going to just continue going through the motions. And we've already, and it's on the judgment on the pleadings, which we've already gone over. So I want to start with that. And then we'll move into the motion to compel and the video. Share screen. All right. So breaking news. Bar case is officially over? Sort of? Wait, what? I don't know what in the world that title is. Like, but he posted this yesterday and he says, we're not going to talk about that part. I want to get to the actual part because I don't give a shit about his AC. He said, the big news is this: while I was having lunch, I got an email from PDJ with a ruling on Jim Lee's motion for partial judgment on the pleadings. And he keeps saying Jim Lee. It's the state bar's motion. Jim Lee is just the attorney that's working on it, along with Henley. But he just wants to blame it all on Jim Lee, and he's like, Jim Lee is just an employee of the state bar. But he says, if you recall, that motion said Jim wins on two issues. One, the claim I violated the court order because, among other things, I published a record showing Laura's weight. Her weight is apparently a matter of national security, and my comments about Mata. First of all, your first claim about you posting about her weight is not why you are being disciplined. It's by putting her medical documents to the public and not just sharing it between the parties. So you're being disingenuous once again, Gingras. But sure, spin it in whatever way you want. Short version of the ruling, Lee's motion was denied as to issue 1, but granted as to issue 2. So that's it, Jim wins. Oh, he's being sarcastic here. As to issue 1, the court said there were factual disputes as to the scope of the court's order. Because, among other things, Woodnick filed unsealed pleadings with medical information long before I was even involved in the case. So Jim lost that part. He didn't lose. Like, nobody's won or lost on the medical pleadings and the medical files and stuff like that yet. It's just still continuing. It's not just gonna be decided right away. But as for issue 2, the ruling was 1,000,000% in Jim Lee's favor. Per the judge, I have no First Amendment rights. The judge, I'm guaranteeing you, did not say that. Did not say that he has no First Amendment rights. He says the US Supreme Court doesn't exist. Yeah, I'm sure that's exactly what that motion or the ruling is going to say, is that nobody has First Amendment rights and the US Supreme Court doesn't exist. And it says the Arizona Supreme Court is free to ignore SCOTUS decisions. All case law I cited was wrong. Well, usually all the case law you cite have nothing to do with your case. You try to make it like you try to put a square peg into a round hole, and it's just it doesn't work. She didn't say you didn't have a First Amendment right to say it. You can say those things, but it could mean that you can no longer be a part of things if that's how you're going to behave. It's your behavior, David. Let's see. Rude speech is never protected, ever, under any circumstances. Yeah, he is being so dramatic here and so extra. Every other court ruling that says otherwise is void. And the Arizona anti-SLAPP law, never heard of it, wasn't mentioned at all. First, you haven't put in an anti-SLAPP law. So the court's not going to even bring up an anti-SLAPP part because it's not in front of her. And rude speech is never protected. Well, you didn't think it was protected when Rob said it, when Rob had rude things to say, but you want to be protected by it. Hello, Angela. I want my speech to be protected, but everybody else that's rude, no. But this is not what that order is going to read. And I'm going to say I can 100% guarantee that the judge is not saying any of that shit that he just said. He says, so let me be honest, which means he wasn't being honest in the beginning. At first, I saw this as a blessing. The reasons are technical, but the main thing is this came as a huge relief. It means, or so I thought, that I could immediately get the heck out of Arizona. And I don't understand why he thinks that or would have thought that. Maybe he was drunk when he read his bar complaints. He said, but then I reread the ruling and realized something. It only resolved one claim in the case, the part about Mata. Yeah, you knew there were several charges about several things. You had even mentioned it in past blog postings. That it only talks about 2 issues. Hello, cornfed. Yes, rules for me, not for thee. That is Gingras' way of living. He said there's still 5 other claims. The court order thing, calling 911 on Maricini, calling JFC assholes, presenting false evidence, and the appeal. But you knew all these things were in your complaint. You answered the complaint about all these things. So you thought that because there was a motion on the medical records, like, it makes no sense. You had to have been drunk. I don't know how else you would have thought that everything was going to be over based on that ruling that is apparently done but hasn't been released yet because it needs to be finalized or something. So he's like, ugh. So that means I still can't leave since I still need to defend those claims, even though this ruling makes the PDJ's view clear. She isn't going to agree with me under any circumstances. Now, maybe if you came with some valid stuff, it would be one thing. Then to make matters worse, even a few minutes a few minutes after that, he got this email that said that, sorry, I need to recall this order. The judge is still working on it. I mistakenly sent it thinking it was completed. So the order wasn't complete. Says it, oh shoot, the order was pretty comprehensive and it certainly didn't look like a draft, i.e., it doesn't cut off in the middle of the sentence of something. Well, maybe there was something like official that they had to do that wasn't done on it, or a signature. Who knows? I'm pretty good at guessing what's going on with stuff, but I really don't have any idea except for this guess. I wonder if the PDJ is going to add something asking/inviting Jim Lee to court, or to let the court know if he still plans on pursuing other claims. Well, the other claims haven't been dropped, so until you're told they are going to be dropped, winning on one issue with you is not good enough. That's not going to get you to go away. The first order didn't talk about the other claims because he wasn't asking for rulings on the pleadings of the other claims, which made me think at first that maybe this was his intended to be a dispositive ruling on the whole case. Well, that's you thinking wrongly once again. But it's clearly not dispositive of the whole case. In fact, because it doesn't even talk about my anti-slap defense, I can and I will technically still raise that. You keep talking about it, but you haven't filed it. Both with the respect to other claims, the calling 911 thing is absolutely within the anti-slap law, but also with the respect to the single claim about MATA. Well, the MATA thing is now closed, so we'll see how that is even taken, which means because MATA has been ruled on, I don't think she's going to have to testify now, is what I'm thinking. Don't quote me on that, but since that portion is over and they've ruled that he violated by the stuff that he said and how he went about it, about Judge Mata, then I'm thinking the Mata portion is over, which should mean the Harry Howe stuff is over. And so he's not going to get to have Mata as a witness or cross-examine her, unless he tries to call her as a witness to everything else in the case. But I don't know why he would need to, but I can see him still trying to. It says, keep in mind, you have to raise legal arguments now, even if you know the judge won't accept them. You can't raise legal arguments for the first time on appeal. So that means I still need to at least make a good faith effort to bring them to the court's attention, even though the judge's mind is made up. You don't know that. But of course, everybody is against you and everybody else is stupid other than yourself. So what's next? Well, since the judge paralegal asked to recall the order, I guess that means technically there is no order. I could still share the draft I received, but as courtesy, I won't. And he says he'll post it when the new filing comes out. He said that he asked Jim Lee to tell Gingras his intentions regarding other claims. And Jim is very confident in his position on the Mata thing is correct. He said, as I've said before, this is a death penalty case and Jim Lee can only execute me once. Okay. Like, I don't think so, because if you were to do other things, they could bring more they could bring more charges or of disciplinary violations on you. And then he said, well, Jim, while he was typing this, Jim responded and said he is not dropping anything else. He is still going to pursue all other claims, so that means I still have to defend them, of course. He strongly disagrees with the judge. Big surprise. He said that I'm actually happy with the context of this ruling. Okay, I don't believe you. Because of the timing will make an appeal much easier for me to win. Keep in mind, Jim Lee moved for judgment on the pleadings offensively, i.e. before any evidence was provided to the court. Because we don't need any evidence. You admitted to things. That was the whole purpose. You said, yes, I did this thing. So there was not, that was the evidence that they needed. You admitted to doing these actions that were ethical violations. The PDJ granted that motion, ending that part of the case. Again, that was based solely on the pleadings, not evidence. You admitting things is evidence because you could have denied it. When I appeal, that means the appellate court, which will be the Arizona Supreme Court, will have to apply a standard of review that is extremely favorable to me. They will have to resolve every inference in my favor. Yet that's not exactly how it works. They have to take it in the light most favorable to you. Possibly. They will have to assume all my factual claims were true, and they will have to resolve every doubt in my favor. Because they will only be looking at the pleadings, not the evidence. But you admitted to it. So they're going to be like, you admitted to this right here. If Jim Lee had moved for summary judgment at the close of discovery, or if he had moved for judgment as a matter of law at the hearing, the appellate standard of review would have been much tougher. Well, you're only going to get this favorable looking as to that one count on the pleadings. The rest of it, they don't have to apply that same standard. And you admitted to it. So it doesn't really matter. It's not going to be extremely favorable to you, in my opinion. But what do I know? Except for every time David says something's going to happen, it doesn't. Because at this point, I would have at least have been given a chance to present a defense. In the context, because the court would be ruling based on the evidence, not the pleadings, the standard of review would be much less favorable to me. Here, I was never given any chance to present any evidence in my defense. For that reason, the appellate standard of review will be the most favorable to me possible, and thus the least favorable to Jim. Okay. Let's see. This ruling isn't final. It doesn't stop me from practicing law. That won't happen until at the earliest. We have the hearing set for the end of June, early July. After that, the PDJ will issue final ruling. You can safely assume the death penalty will be imposed. Well, I'm glad you know your behavior is so abhorrent that you should be disbarred. And he says, does that finally mark the end of my days as a lawyer? No, not necessarily. Once the PDJ issues a final decision, I can appeal it. As a part of the process, I can ask for stay pending the appeal. If the PDJ issues an order suspending/disbarring me, and if that order is stayed, that means I would be able to continue practicing law until the appeal was resolved. And then he will remain licensed in California, he says, for a long time. I'm 100% confident the CA bar will not recognize this order because, among other things, it directly conflicts with California law. I'm really not practicing anymore, and I don't intend to continue practicing in Arizona regardless of the outcome. But the rule seems to weigh heavily in favor of automatically staying PDJ rulings in most cases. In fact, look at what the rule says. The application for stay pending appeal shall be granted subject to appropriate conditions of supervision, except when an interim suspension has been ordered, or when the hearing panel, in its discretion, determines no conditions of supervision will protect the public while the appeal is pending. Well, there you have it. Um, he says, "But keep in mind, I want the US Supreme Court to take this case." Of course you do. I can't ask them until the Arizona Supreme Court says I lose. So we are now one step forward. So he's like, I want the Supreme Court to take this case. So I would like to lose this case, lose my appeal, and then the US Supreme Court can say, see, he has First Amendment rights. Yeah, it's just a whole bunch of bullshit. I think people told him, yeah, I think he was an idiot to represent. He is an idiot to represent himself. And I think the problem is he wants to say it this way and nobody will spin it that way. Even Mark Randazza will not spin it that way. Um, oh my gosh, yes. If y'all did not watch over on Beacon Bear's channel, I think it's That's My Opinion or something. Going back and watching the debate thing or conversation with Reality Steve and Rachel Juarez was it was crazy, and I was laughing so much because she is reacting how all of us are, getting shouty, getting passionate, and because Gingras makes you feel like you're going insane because you are like, "That can't be real. That this is not reality." And yes, that it is the epitome of digital violence. Um, Laura does Chingers is definitely violence every day, to our eyes, to our ears. He is a gaslighter for sure. It's just but I was like, "Okay, so they've taken the Mata thing away from him, but I feel like he's still gonna try to pursue Mata in some way." Um, I don't think he's ready to fully drop that. So, now let's bring up I remember that he did let the subpoena thing slip. I I forgot how often he was like, "Yeah, don't let me talk." And it's like, "Dude, you have talked this entire time." And Rachel Mitchell is just sitting there. Or not Rachel Mitchell, I'm sorry, when I was reading the comment. Let's see here. Mm. This one's only 7 pages. Alright. Yeah, it was interest and it is always interesting to go back and listen, and watch because that was one thing with listening to this podcast and, you know, Snitchel Ninja does the after show basically with Stephanie Young, and she does the emoji things, and the penguin one, I was like, "How did I forget about the penguins?" Because I thought that, like, the penguins of Madagascar coming on the screen and dancing and everybody doing it, and Clayton did it too. I was like, "Oh, that's so funny and that's cute." And so, I was like, "Oh my god, I forgot about that." And the Chase J. Jones and stuff, and it's nostalgia for us. Okay. Actually, I think I have to go over this one first. Promise we will get to the video. Most of y'all have probably seen it already. But we want to get caught up on this stuff. And I'm so far behind. And yesterday not being able to do the live stream really put me even further behind. Of Moose and Men. I like that. Title for Bruce's autobiography, Of Moose and Men. Love it. I vote. Okay. Since Dingus's motion to compel also talks about the motion to quash, we are going to go over that here. So this was filed March 6, 2026. Attorneys for the Non-Party Commission on Judicial Conduct in the Supreme Court of the state of Arizona before the presiding disciplinary judge, the PDJ, in the matter of member of the State Bar of Arizona, David Gingras, non-party objection to subpoena Deuces Tecum for Commission on Judicial Conduct records and motion to quash. Because we know Dingus sent out the motions to quash, or motions to subpoena them and stuff, which I will put that in a different video. So, pursuant to the Arizona rules of Supreme Court Rule 47H3, the Commission on Judicial Conduct, the Commission, by and through undersigned counsel, hereby respectfully moves the presiding disciplinary judge for an order quashing portions of Gingerbread subpoena. The subpoena was emailed to the commissioner on February 25th, 2026, rather than personally served as set forth in Rule 47C2. Respondent indicates in his cover letter to the commission that the subpoena is being served on the Arizona Attorney General's Office, AGO. The AGO generally has no authority to accept subpoenas on behalf of individuals or entities, nor does the AGO act as a custodian of records for the commission. So they're saying he didn't do it right. But those were dated on February 3rd, 2026. And they say, for the reasons set below, the commission is a non-party in this matter. Undersigned counsel affirms that this motion is not made for the purposes of delay and is in the interest of justice. So we kind of get to see the subpoena here. Says the subpoena seeks copies of all documents related to any/all complaints or reports of misconduct involving Judge Julie Ann Mata, respondent judge, sent to the Commission on Judicial Conduct, the CJC, including but not limited to documents relating to CJC, which yeah, DG is living in an echo chamber. My daughter just came home and she's just so loud and distracting me. All right. Which It would be one thing if it was just things that were sent to the CJC about him, but anything ever is not relevant. So, this request shall include all complaints received. Hello, Bacon Bears. I was just saying how much I loved your reaction to the debate thing because you were reacting just like all of us. The documents reflect how each complaint was resolved. All correspondence sent or received from the respondent judge and or her counsel or representative, if any. I'm thinking some of that stuff is attorney-client privileges. Yeah, it's sadly, your recovery is gonna be pushed further and further back. It's going to take a long time because you keep you're gonna keep getting triggered. Um, that is a part of this cult. We just one day we might recover, but every time we think we have, something else happens, unfortunately. You need some good coping mechanisms. All documents and records obtained by the CJC from any source in connection with any complaint against Judge Julie Ann Mata. I don't think copies of any recorded statements obtained by the CJC from any source in connection with any complaint against Judge Ann Mata. Copies of any documents reviewed or considered by the CJC in investigating any alleged misconduct by Judge Julianne Mata. If this is about you, Gingras, this is not Judge Mata's disciplinary hearing and disciplinary action. This is yours. So stop saying you need all this stuff that doesn't pertain to your behavior, your actions. If Judge Mata or Woodnick did something else, that has nothing to do with your disciplinary. That's like siblings saying, well, he did it too. She did it too. Okay. Well, right now I'm dealing with you and I'm going to handle you being disciplined. And then if I need to go and discipline your brother, I will go and discipline him too. But what your brother did has nothing to do, excuse me, nothing to do with your punishment. Just, what about him? What about yourself? Yeah. Copies of any other evidence in kind which CJC considered in connection with the CJC case involving Judge Mata. Yeah, that case is not this case, I'm guessing. Objections. The commission, a non-party in this matter, is created by Section 5 of Article 6.1 of the Arizona Constitution, which states the Supreme Court shall make rules providing for confidentiality of proceedings. These rules, CJC, govern the Commission on Judicial Conduct and are promulgated by the Arizona Supreme Court. CJC Rule 9 governs public access and confidentiality, and what information becomes public is largely driven by the outcome of the complaint. In an effort to eliminate the potential confusion, all requests will be added herein with the lettering as set forth in the subpoena itself. To the extent that the documents can be released, instructions to retrieve them electronically have been provided to the respondent, Gingras, via email, which that's in blue. I don't know if that just automatically happens, but that's not in black and white. So, you know, Prior to the filing of this objection, the reference commission case arose from one complaint, respondent Gingras. And I don't care about that email address being out there because it's his law office web email. It's his public email. All complaints received. Mr. Gingras was the only complainant in commission case. Hello, French Psycho. I think I saw you in Rosalind Duke's chat earlier. Look up If You Give a Mouse a Cookie. I love that book. I love those series. I think her mom is very, very involved. Did you listen to the latest podcast that just dropped, Bacon Bears? Because it talks about kind of how involved her mom is. Let's see. So it was the only complaint in commission case and can be provided with an unredacted copy of the complaint and supplement materials he filed. Judge Mata has no public discipline with the commission. All of Judge Mata's dismissed complaints filed by other individuals, to the extent there are any, would be confidential pursuant to CJC Rule 9A1. Yes, the podcast that came out today was so good. I'm sorry. Documents reflected how each complaint was resolved. The commission can provide Mr. Gingras with an unredacted copy of the disposition order in the commission case. These are the same documents previously mailed to him on February 12th, 2025. So they're like, we already sent you this shit. Complaints as defined by the CJC rules are entitled to written notice of the disposition of their own complaints pursuant to CJC Rule 10. Any dispositional orders on the other complaints filed against Judge Mata, to the extent there are any, by other complainants are confidential pursuant to CJC Rule 9A1. He just wants all of the dirt, and he's not entitled to all of the dirt, if there is even dirt to have. All the correspondence sent to or received from the respondent judge and or her counsel or representative, any Judge Mata's response in commission case, whatever, is confidential under CJC rule. The commission may discretionally disclose a judge's response to a complaint pursuant to the CJC rule. Mr. Gingras made the request February 10th, 2025, and it was denied by order dated April 2nd, 2025. To the extent Mr. Gingras may be seeking Judge Mata's response to any other complaints that he did not file, those are confidential as well. All documents and records obtained by the commission from any source in connection with the complaint against Judge Mata, those are confidential. Copies of any recorded statements obtained by the commission from any source in connection with the complaint against Judge Mata are also confidential, as well as copies of documents reviewed or considered by the commission in investigating any alleged misconduct of Judge Mata. Yeah, he doesn't get to know that stuff. He just gets to know stuff about his case. That's it. Copies of all the evidence of any kind, that's vague and ambiguous, which the commission considered in connection with that particular case involving Judge Mata. Complaints, to the extent they exist. So they're saying if there is any, they're confidential as well. For the reasons provided above, the commission objects to the production of additional records beyond what has been provided and asks the court to quash the remainder of the subpoena. Respondent Gingras has been asked to withdraw the remainder of his subpoena as to the commission, but has indicated that he will not do so. Yeah, they've already told him no, and he still doesn't give a shit. To the extent this court is considering compelling the releases of such documents, the commission asks this court conduct an in-camera review to determine if the relevance of any of the document demands release in light of the existing CJC rules, and that any release be pursuant to a protective order. Further, it is requested that before any future subpoenas or requests for depositions are granted, to the extent any are made, the commission, a non-party, be heard. This will help alleviate an unnecessary use of public resources going forward. And this was filed on March 5th, 2026, by Attorney General, and it was kind of signed or witnessed by Assistant Attorney General, attorneys for the Commission on Judicial Conduct. And then the good faithist, that they made a good faithist basis. They had sent an email and all that to do a meet and confer. And it was sent to the proper people. Okay, you can lurk. Go pick up the kiddos. I completely understand that life. I'm thankful that my daughter will soon be. They don't have their own cars yet, but they will soon have cars, and I will not have to be an Uber all the time. An Uber that doesn't get paid, that's your life as a teenage parent. Just wasting all the gas. All right. So now we have this motion to compel. And this is what triggered the hearing, because after he filed this, they they had to give him a hearing within a certain amount of days. I think it was like 5 days or something. Let's see. No, Uber isn't free, but when you're a parent, you do not get paid. So it is free for your teenagers most of the time. Let's see. Henrietta brings up, before we get into this, in the very first set of indictments before consolidation, there was a document about there was an accomplice, and we've heard no talk about naming an accomplice since. Anyone have thoughts? It could be that they're not going to go after him right away, or that they're going to offer them a deal if they continue to, if they cooperate. The thing is Jan's not going to cooperate or testify truthfully if it's Jan. I still think the accomplice is Jan. I don't know how much the sister fully knows. Just because she, at least during the Clayton part and the Greg part, her sister wasn't around like most of the time, because her sister doesn't live here or in Arizona. Now with Mike, her sister might have had more of an impact. Dingus, I don't think can be an accomplice, as far as, now he could be a later accomplice. But as far as what she did to Greg and Clayton, when he wasn't even in the picture until late March, when all this started, I don't think Dingus could be the accomplice, unless they're saying that he was an accomplice in trying to get this lie and scheme done. Yes, I would love to know what was on Jan's phone, because to me, it reminds myself that, like, when adults will do something, that, and maybe they'll use like the kid's computer or their wife's computer, or they'll use somebody else's electronics because they seem to think, well, if they don't find it on my electronics or if they look at somebody else's, it's gonna draw attention to them and not me. But it's like, how stupid can you be? When they have the right to all the electronics when they get subpoenas because they're not gonna trust you to tell them whose is who. Like, because you could lie about it. So they're like, "Yeah, we're just gonna take them all. We will sort out the rest. Thank you very much." Speaking of this, like, Gingras, did you say meeting the fat people? I like that when I do, some of my, like, AI thumbnails, it seems to be making Gingras's face fatter and fatter, which I find hysterical. Um, but that's just my humor. All right, let's get on with this motion to compel. So, this is Ginger Ass's Gingerbread's motion to compel, filed on March 23rd, 2023. I don't know what second means. I guess it's his second motion to compel. But Dingus respectfully moves for an order compelling two non-party witnesses, Julie Mata and her father, Harry Howe, to comply with the subpoena served on them. I bet you would. And then there's a footnote. Let's see. Mr. Howe and his daughter, Judge Mata, have also separately moved to quash the two subpoenas in the interest of creating a clear record rather than treating this motion as a response to the motion to quash. Respondent will file a separate brief in response to both motions, even though there's admittedly some overlap between the two briefs. Yay, more paperwork from Gingras because he just can't stop, won't stop. Introduction. The court has 3 discovery motions to consider: this motion to compel and 2 motions to quash. These motions may appear at first to raise simple discovery disputes. In truth, the outcome of these 3 motions will have major, almost certainly dispositive impacts on the case. To avoid confusion, because, you're just a girl judge. I know it's easy for girl people to get confused. You're just not as smart as men. To avoid confusion before discussing other issues, it is important to be extremely clear what this motion is not intended to do. It is not intended to act as a veiled attempt to get the court to change its prior rulings regarding records respondents sought from the Commission of Judicial Conduct, CJC. This point is important, so it will be addressed first. Great. 2 weeks ago, on March 6, 2026, respondent filed a motion to compel seeking records held by the CJC. On March 11th, 2026, the PDJ issued an order denying the motions. Yeah, denied, sit down. In that order, the court quoted from the bar's complaint, which accuses respondent of making false statements regarding Judge Julie Mata. After quoting the bar's allegations, the court summarily stated respondent Gingras was not or has not demonstrated how the outstanding items in the subpoena, Deuce's Tecum, would assist in his defense regarding such. Your statements. They're your statements, Gingras. If they were Judge Mata's statements, maybe you would need something from her, but you're the one that made the statements. So you have all the information about the statements because you're the one that made them. You're the one that has to answer these questions. No, he doesn't do anything respectfully. And he talks about offensively, and I'm like, sir, you are a walking offense. You offend everybody just by being on earth. Later that same day, on March 11th, respondent moved for relief from the order denying the motion to compel. In that motion, respondent asserted the PGJ's decision appeared to have been based on an argument that was never raised in CJC's objection, i.e., that the records in question were not relevant. Well, they're not. Respondent then explained the CJC records were plainly relevant to the issue of whether his comments about Judge Mata were true or false. Respondent explained truth and falsity is a central issue in this case because, as multiple courts have held, attorneys may be sanctioned for impugning the integrity of a judge or the court, only if their statements are false. And then he cites a case. And from what I've read, it looks like, we'll see what the order says. Whether his statement was true or false, he cannot be acting in the manner that he was. And the comment in his filing, the "look at me, daddy" comment, was egregious all by itself. If you take out all the other ones and you just focus on the "look at me, daddy" comment, done there. I am wondering, y'all talk about Jan and Ron. I'm wondering if the reason Ron is possibly going to California is, are they moving to California? And that's why Ron is going to go. Because Laura is just going for a visit. But is Ron and Jan actually moving there? Which I'm sure Sarah is so pleased if they have to go live with her for a little while, or they're living close to her. Yeah, sure, they'll get to see the grandbabies and all that. I don't know if they're moving in with Sarah, but I'm wondering if, because Ron hasn't, I don't know if Ron's gone on the trips, and he is going on this trip apparently this time, from what the rumors are. So I'm wondering if it's because they're moving there, because of their house being foreclosed on. Because they have what, like less or a month or so before they actually have to be fully out, I think. I forget when the house is being foreclosed on. From my understanding, Laura was there, Jan was there, in court in person today. And Greg was also there. Those are the main ones I've heard. So let's see here. Truth or falsity. And he says truth is an absolute defense to any statement made by an attorney that impugns the honesty or integrity of a judge. That's a case. Let's see. After respondent explained the CJC records were relevant, the following day, on March 12, 2026, this court issued a second order affirming the court's position that respondent was not entitled to obtain records from the CJC. In that order, the court explained respondent's point about relevance was misplaced, i.e., because court records indicated the motion to compel was not denied on that basis. The court further explained the order to quash granted relief because of the confidential designation that the Arizona Supreme Court has given the documents in question under the CJC rules. To be very clear, And to put this as politely and respectfully as possible, you don't know how to be respectful or polite to anybody, especially a woman. Respondent disagrees with the court's legal conclusion. You disagree with everybody's legal conclusions. In his prior pleadings, respondent noted confidentiality, and it's not a basis for withholding otherwise relevant information. That's why they also said then maybe there needs to be an in-camera review so that they can decide if it is even relevant or not. He says there's no absolute privilege for trade secrets and similar confidential information. Well, I don't know how the Federal Reserve and Federal Open Market has anything to do with your case here, but okay. The Arizona Supreme Court agreed with this rule in another case. In that case, a party refused to answer interrogatories on the grounds they asked for information of a highly confidential nature. The Supreme Court rejected the argument and held confidentiality was not a valid basis to withhold otherwise relevant information and discovery. Instead, the party or witness holding confidential information must produce it subject to a protective order if warranted. Yeah, well, none of that's been done here, but keep trying, I guess. Defendants further objection to this interrogatory on the ground that it calls for confidential information. We know of no case holding that this is proper ground for an objection to an otherwise proper interrogation or interrogatory. Assuming that the information called for by this interrogatory is of confidentiality nature, which defendants do not want to have included in a public record, they presumably could have applied for a protective order. Yeah, they just don't want Dingus to have some information that he's not entitled to. That's it. Similarly, in United States versus Nixon, because of course he has to bring up politics. The U.S. Supreme Court unanimously held a non-party witness, even the President of the United States, could not withhold relevant evidence sought by a subpoena on the confidentiality grounds. I would like to know if these are disciplinary hearing things. Because to me, he should be quoting things that have to do with disciplinary hearings. Am I wrong? Let's see. I'm going on May 28th. They're going to Arizona days after the auction. May 26th is the auction. Okay. So yeah, that's the thing is Laura can't stay there. She can go visit and help them get all situated, but she can't stay there. Just like Gingras is like, I would like to get out of Arizona. He doesn't have permission to leave Arizona currently. Even if this is done, until his DUI is done, he does not have permission to leave Arizona. He is out on bond, just like his felony alleged client. She's a felon, like, whatever. Like, she's not convicted yet, but she's a felon, in my opinion. So, him talking about, oh, he has the right to all this thing, that might be true in a criminal case. Some of it might be true in a civil case. Is it true in a disciplinary case that you get the right to everything? I mean, you might, but I would like to hear stuff that has to do with like the PDJ and the CJC and stuff like that. Not Watergate. Because Watergate and your state bar disciplinary hearing are different. Having said this, to avoid any misunderstanding, respondent is not asking the PDJ to revisit, reconsider, or otherwise change the two prior rulings related to the CJC records. The PDJ has spoken on that issue. At the same time, these points are mentioned because it's possible that the court may believe the current motion implicates the same confidentiality issues, even though it does not. Here's why the subpoena issued to Judge Mata requests much of the same information respondent asked the CJC to produce. That's certainly true, as Judge Mata's motion to quash begrudgingly notes, but that does not mean this court has ruled on the separate question of Judge Mata is required to comply with the respondent's order. Now is time to do that. So the CJC is like, we're not handing anything over. And Mata's like, I'm not handing anything over. Unless a judge tells me I have to hand something over, I'm not handing it over. And so he's like, Judge, will you make them hand it over? Again, because of this issue, a little subtle, let's be very clear, as to the CJC records, this court denied respondents' request to obtain those records because it concluded the CJC's confidentiality rules provided a valid basis for the CJC to withhold this information. Respondent understands the court's ruling, but respectfully disagrees with it. And he could be doing all of this, one, because in his mind, he thinks this is going to work, or two, he's just making sure he saves it for his record on appeal. Because the appellate courts may be like, no, they should have given it to you. I don't think that's going to happen, but that may be how he sees it. The same confidentiality argument does not apply to Judge Mata. Nothing in the CJC rule provides the judge against whom a complaint has been filed may subsequently withhold otherwise relevant information in response to a subpoena, such as the judge's written response to that complaint, simply because the response was also sent to the CJC. The CJC rules say no such thing. But her CJC things that have happened in other cases, if she's been disciplined, has nothing to do with you in this case. This is focused on your behavior in Owens v. Eckerd. Period. End of story. You don't need anything else. The argument, if raised, would be like claiming a client involved in an auto accident could refuse to answer any questions about the accident just because the client later discussed the incident with the lawyer. That's not what's happening here. Because that would be about the same damn accident. But they don't have to talk to you about another accident that happened when you're supposed to just focus on this one. I don't even know, was he the lead attorney at the Dirty? Or was he just an attorney and then ended up just being the face of everything? Oh my gosh, I just sneezed. I don't know about y'all, but the pollen and the allergies have been kicking my butt. So he just ended up being the face to go on Dr. Phil when he wasn't even, yeah. He hasn't seemed to be the lead anything when he talks about his cases. He is just like a co-chair. It's not him and him only. Because I would like to know what his record is on cases that he has fought by himself without, like, not being second chair. And if Randazza was the lead, Randazza could have been like, yeah, sure, go on Dr. Phil to talk about it, because Randazza was like, I'm not going on Dr. Phil. I don't know if that's how that went down, but why was Gingerbread on Dr. Phil and not the lead counsel? They were just like, yeah, sure, if you want to go do that, you can. I'm not putting my face out there for that. Although attorney-client privilege protects a client's discussions with counsel and shields those specific conversations from disclosure, the privilege does not shield any of the underlying facts simply because they were shared with a lawyer. Then he quotes ARS 122234C, explaining attorney-client privilege does not permit party to be relieved of duty to disclose the facts solely because they have been communicated to the attorney. The point here is simple. This court denied respondents' request to obtain records from CJC. It did so because CJC's rules say records held by the CJC are confidential. Judge Mata is not the CJC, and her motion to quash does not claim she's entitled to withhold information on the same grounds as the CJC. Okay, well, even if they say even if Judge Mata's counsel says it's because of confidentiality, the judge can say their objection is this. I don't agree with that objection. I find it to just not be relevant. And I've seen many judges, I don't know if they're supposed to do this, have their own objection. I don't think they're supposed to do that. Now that makes me want to see, did they state anything about, because he's like, all they said is it was confidential. Mm. Let me see here. They should have put relevancy in there because the judge shouldn't come up with her own objection. Let's see. Wait, further force me. Yeah, they would like, but they do bring up here. I'll switch it over to this. And I'm going to use a highlighter because David's not allowed to. Because he says, oh, they didn't bring up irrelevance. It says here, to the extent the court is considering compelling the release of such documents, the commission asks this court conduct an in-camera review if the relevance of the documents demands release. So they did. So they did bring up relevance. So they're like, they didn't even bring up relevance as an issue. So respectfully disagree. Where did it go? He disagrees with that. The same is true with respect to the records for Judge Mata's dad, Mr. Howe. He says it's directly relevant to the issues in this case. It's not privileged, nor is it arguably confidential. The only argument Mr. Howe raises is that he's a non-party and such. He is unable to determine if any requested documents are relevant. That's not a valid objection, either factually or legally. Mr. Howe's motion should be denied, and this motion should be granted. He didn't have any documents relevant to this. So he's like, I don't know if I even have shit that goes to this, okay? But he's like, give me all your text messages. The State Bar has charged respondent with making false statements impugning Judge Mata's integrity, among other things. Respondent accused Judge Mata of violating the Code of Judicial Conduct by performing an extrajudicial investigation into the facts of Owens v. Eckerd by making a factual finding that was not based on admitted trial evidence and which was based on information Judge Mata obtained from an ex parte source. But you don't have any proof of that. Also, It makes me wonder. Let's see here. Did they actually charge him with making false statements? Because now I'm curious. That's probably not going to work. Okay. Or if they just made allegations that he made statements. I may have to look. Okay. Findings that was not based on evidence, admitted trial evidence, discussions about the case with her father, Mr. Howe, which included sharing pleadings from the case with him and discussing those pleadings with him. You have no proof of that. The details of respondents' accusations against Judge Mata were set forth in the 21-page affidavit filed for the change of judge. We've already read all that. As the affidavit explained, immediately following the trials, multiple witnesses gave video recorded statements claiming Judge Mata's father, Mr. Howe, secretly attended the trial. Who said he secretly attended? And told spectators he was not there to support his daughter, but he had been hearing about the case and was here for the circus. It doesn't mean he heard about the case from his daughter. At least one witness claimed Mr. Howe said he had been discussing Owens with his daughter. Who said that? That she printed case-related documents for him and that she had discussed those documents with him. Okay. So, Justice for Clayton, IG, said Judge's dad waiting in line. And not YouTube lives or social media conversations since the trial, her role and involvement in the case remained. The pick Hava took to give credence to her claims, the judge gave court docs to her father, which Laura used in her complaint that the judge is biased against her. Well, maybe that was misreporting because Bruce knows who gave it to him. Right. If he was there secretly and Judge Mata didn't know he was there, then yeah, how did she be like, look at me, daddy, if she didn't even know her daddy was there? His arguments make no damn sense. And the fact that you're getting all your source information from just one person and applying it to everybody, it is crazy to me. Like, provided by his daughter. And this is why, if you don't know something, you need to not post it. Like, if it's a rumor, you need to make sure that you've heard through the rumor mill. You don't have any verification on it, but don't be putting things out there like they're fact. And stop saying that everybody thinks or is saying the same thing as everybody else. Because we don't all agree or disagree on every single thing that somebody in the JFC does or is a part of. Despite this, after investigation for more than 7 months, the CJC somehow determined respondents' allegations were not supported by clear and convincing evidence. However, the CJC has refused to reveal anything about how it reached that conclusion and has refused to disclose any evidence it considered. Well, that was hers, and they told you they didn't find anything clear and convincing because all you had was speculation that you submitted. There is no definitive proof that what you are saying is true. Despite filing charges accusing of the State Bar Judgemont's father, the State Bar has disclosed no evidence of any kind to support that charge other than a disclosure statement indicating Judge Mata has denied any wrongdoing. Again, with zero explanation. Well, she's denied everything that you've said about her. That's the wrongdoing. All the wrongdoing you said she did, she's denying doing. That's your explanation. Everything you said was false, is what she said. What else is there to say to that? What other thing do you need? She's denying this. In this posture, there is clearly a factual dispute where respondents' allegations about Judge Mata and her father, true or false. As noted above, a lawyer cannot be disciplined for publishing true statements criticizing a judge. Accordingly, any evidence that proves the truth of respondents' claims is relevant and thus discoverable pursuant to Civil Rule 26B. The thing is when you post the statement, you either know at the time that what you're saying is true or false. If you do not know it to be true when you make the statement, then you're not supposed, you shouldn't be saying it. Because the fact that you're still trying to prove if what you said was true right now makes it false. Because you don't have anything to say it's true. Emily D. Baker did a stream, I believe it was yesterday, about the TikTok psychic Brian Koberger stuff. And she does talk about the fact that TikTok psychic that she wants evidence to prove that what she said about the person that, the Idaho 4, she wants proof from the courts that what she said about who murdered them was true. And EDB, Emily Baker, says that she needed to know that information when she made the statement. Not now. She didn't need to try to get information now. She had to know this statement was true or false when she made it. Not it so happened to be true, but you said this. I know. Somebody's gonna have to come brainwash me, because we're not all one brain. And so I guess my cult brain is out of whack because we don't all think the same thing about everything. I know it's crazy. We have our own brains, guys. Disability discrimination when she mentioned him signaling. He was asking her to speak up because he was deaf. You know what's funny is he talks about, he brought up, "Oh, I was deaf, so I couldn't hear." That's why I needed to X because I couldn't hear because this is the national sign language for I can't hear. But we know he was doing like this or whatever too, but he's not had a problem hearing in any other circumstance that he's been in. Not in his debate with Reality Steve. I don't think that he did with Just J. Hip. And any other court hearing that we've had since, it's funny because he has had no problem hearing in anything else. But he's apparently partially deaf at some point, and apparently his eyes are fucked up. I don't know. Oh, he does admit to signaling to her. He fully admits to that. But he says he couldn't hear and that he was quieting the witness, which was allowed. Well, maybe some of that was about that, but most of it, no. She needed her emotional support Gingras there, and since she got blocked from seeing her emotional support gingerbread, that she panicked. It was not because of Mike Marancini or any of that. Let's see. The subpoena seeks relevant, non-privileged evidence, correspondence, but he wants to know everything that if he's ever spoken about Owens v. Eckerd with Mata, and if he has, and it's in text messages or emails, then he wants him to hand it over. And maybe they have talked about it. Doesn't mean it's an email or text. It could be through the phone, but there's no proof of it. So they could just tell you whatever, and you don't have any proof. That's why it's funny when people do things with text messages or emails where there's like a paper trail, and it's like, there was ways to go about things and it not have a trail back to you. Mr. Howe does not assert privilege, nor does he claim the volume of responsive documents is so large to constitute an undue burden. He says he doesn't have anything that is relevant to you. Mr. Howe's relevance objection should be overruled. Yeah, he should just hand over a Celebrite report. Mr. Howe and Judge Mata should just hand over Celebrite reports of their phone to Gingras. Let's just do that because, all that's relevant. He wants to be extra and extreme and all that. Yeah, he would just like Celebrite reports of everybody. Let's see. And then he cites cases that don't seem to have anything. Talks about Hawaiian rules. Hawaiians, I think, run their courts in different form than most states. Court of Appeals also held any privileged objection was waived because the lawyer placed the privileged information at issue by using it to support his allegation against the councilman. The court should follow the same logic. Unlike her father, Judge Mata's objections focus primarily on privilege, arguing judges can not be asked to explain the basis of their decisions. To be clear, respondent generally agrees with judicial thought privilege, limited to the ability of disappointed litigants to demand a judge to answer about their legal thinking and analysis. This argument has no application here for two reasons. Respondent subpoena seeks documents which have nothing whatsoever to do with the judge's legal thinking and analysis in Owens. Even if respondent did seek that information, Judge Mata has waived any privilege that would otherwise apply. They are all waivable under appropriate circumstances. He's saying privilege can't be used as a sword and a shield. She shouldn't be able to waive privilege on this. Oh, choose. Okay. Judge Mata to invoke privilege so she can withhold information that may be unfavorable to the bar's position. You're supposed to have all this knowledge when you make statements. He says Mata's objections are groundless. And she says that it's a fishing expedition and it has She also claims respondent is engaging in you are engaging in a fishing expedition. You're searching for stuff that you don't have. Okay. So now I want to go and look. Let me see. Is it in this one? Ah. Oh, okay. So he apparently does have the document. We'll share this now. He's not willing to share the document on the ruling because that was yesterday's when we started it. Now he has a new one. Jim Lee just filed a motion for judgment on the pleadings. Oh, sorry. This was from March 9th. What am I thinking? Today is April 9th, not March 9th. Okay. And we'll stop sharing that. Too many days. Damn it. Let me see here. Damn it, because Victims of Laura Owens is not working for me. Oh, wait, maybe it is. Okay, I want to pull up. I want to see if they actually say they're false statements. Bar issues. Okay. Okay, amended bar. Oh, no. Damn it. Okay, well, I don't think I have that one in the file. Hello, Taz. I do have the amended bar complaint. Okay, good. Okay. That's what I wanted to see here because that's about the motion to seal, motion to compel. What is this? That's all about the medical shit. Let's see here. That's about Mike Maricini because that hasn't been ruled on. Okay. So let's look at this. He keeps saying that they said that he was making false statements. The bar from this amended complaint does not say that he made false statements. It says the disparaging comments about Maricopa County Superior Court Judge Julie Mata. Respondent knowingly made unprofessional, disparaging and inappropriate comments about Judge Mata's qualifications and or integrity in documents filed with the court and in posts he made on social media. So, it was unprofessional and inappropriately and disparaging. Let's see here. I don't see anything. He's using it means that have no substantial purpose other than to embarrass or burden with reckless disregard to its truth or falsity. Okay. Yeah, there's reckless disregard for the truth or the false of it because he doesn't know whether what he's saying is true or false. And he has to know when he makes a statement. Okay, including by making public statements about Judge Mata's qualifications or integrity that were objectively false or made with reckless disregard as to their truth or falsity. Because Gingras doesn't care whether the statement he made is true or false. He just doesn't. Okay. So we will watch. Let's watch here. All right. We will watch the let me go to it now. Let me go to law and crime. I guess I'm going to have to go to Twitter to find it. Oh, okay, Court TV. Okay, I guess I need to subscribe now. It's not even 3 minutes long, so we'll watch this real quick. Nothing big is happening here. All right, let's share screen. Bachelor baby scam suspect shows up in court is what they've got it labeled as. All right. So let's begin. All right. There we go. All right, now press play.
All right, this is CR 2025-007905, State versus Laura Owens, time set for a complex case management conference. Can I get appearances, please? Mr. Cotto, can I get the state's appearance, please?
Which number, Your Honor?
Number 10.
Kevin O'Connell for Ed Leiter on behalf of the state.
Thank you.
Good morning, Your Honor. Christian Lueders on behalf of Laura Owens, who's present with me at the podium out of custody.
All right, good morning. Ms. Owens, can I get your name and date of birth, please?
Laura Owens, 5/14/1990.
All right, thank you. All right, I did get the complex case management report. Thank you for that. Mr. Lueders, anything you wanted to talk about today that isn't encompassed in that pleading?
We did not talk about the motion to permit out-of-state travel that we filed last week in the CCMC report.
Yeah, I did receive that. State have a position.
Your Honor, the state takes no position on that particular request, and victims' rights have been complied with.
Okay, thank you. I'll go ahead and grant the motion. Ms. Owens be permitted to travel to San Diego, California between April 10th and April 17th, and then from May 28th to June 2nd. All other release conditions remain in effect. As far as, looks like we got dates in July. When do you want to come back for another complex case management conference?
So there is a plea deadline on the books right now for late in April. Mr. Leiter and I have talked about extending that just because of the volume of discovery. I'm still going through it. We're going to need a little bit more time, but I think that a mid-May date probably, and I'm looking at if Your Honor has room on his calendar, the week of May 18th. I'd love to come back then. Realizing that Mr. Leiter hasn't actually given me an extension. I don't know if you had anything in the notes, Kevin, about that, but I think that week would be good to come back for a CCMC.
All right, can we accommodate that?
May 20th at 8:45.
How's May 20th at 8:45?
That works for defense. Thank you.
Is that good for the state?
Yes, Your Honor.
All right, in the event you have trouble with the extending the plea deadline, we can get you on the calendar as needed if you need anything. All right, so Ms. Owens, you need back in my courtroom May 20th at 8:45 for a complex case management conference. Final trial management conference is July 22nd at 8:45, still in this courtroom. Trial assignments July 29th at 9 o'clock before the trial assignment judge. Same building, 5th floor, courtroom 5B. If you fail to appear, warrants can issue for your arrest. If you don't show up for trial, could occur in your absence. Got all that?
Yes,
Okay.
thank you, Your Honor.
Thank you. We're in recess in this matter.
Thank you, Judge.
Okay. I hope they don't extend the plea. I feel like they might, unfortunately. But, oh my God. Well, we've talked about extending the plea. But they haven't told me they would. I don't think Laura needs an extension of plea. Maybe the lawyer does, but Laura doesn't need one. Are you going to fess up or are you not? Like, I'm so tired of her fucking games. But I'm guessing she got denied to appear virtually, or they didn't just answer it. And so it does seem like she's going to travel starting tomorrow, which meant she was going to be in town for today. She wears the same shit to court every day. So I don't know why she's like, oh, I need to appear virtual. Why? You wear the same shit. It looks like the same shit every single time. That's it. We just want updates on your case. We don't actually give a fuck about what you look like or anything else. She just needs to stop. I'm so over her bullshit. I'm over all of this shit. Because just admit up to your wrongdoings. That goes for you, Gingras. That goes for Laura. Like, just cut the shit out. Y'all know y'all fucked up. Just take your beatings and consequences and go on with yourself. All right. Now I'm going to go to the motion to compel hearing on Schnitzel Ninja's channel. So we're going to share that screen because that motion that we just read a while ago goes to why this hearing had to happen. And as always, it goes well for Gingras, right? Or the reason it doesn't go well is because everybody just is against him and Laura. And everybody else is just stupid. And he's the only one that understands the law. All right, here we go. What in the world? Stop it.
Schnitzel Ninja.
Testing 1, 2, 3.
Alright, so we are on the record, and this is with regards to PDJ 2026-9010 in the matter of David S. Gingras. And before I take notices, I will note that we do have a public member who is connected in. They are the only public member that we have received a request to participate in this telephonic. However, of course, we would accommodate such because this is a open and public proceeding. However, I do want to highlight it is a proceeding. It is a.
Okay. So first I want to say, it is said, unless Gingras didn't hear it because he was deaf, that there was somebody on the call from the public. And Dingus still wanted to go and blog about how this hearing went for him. And he mischaracterizes things. And the judge actually tells him he mischaracterizes things because he doesn't ever fully characterize things the way they actually are. Because he's disingenuous. And knowing that people were going to hear this hearing or have a transcript or something from this hearing, and he still got him on his blog with all his audacity and represented it as something else. But he is just so, he hates people that lie. But he doesn't hate himself. It's weird.
Status conference that this court, the PDJ set. And so I will just remind all folks that are present that Rule 122 does apply. So this matter is not to be recorded unless they have complied with Rule 122H if it's a personal recording. And if that were something that someone did comply with, then I would just remind the folks that are present in the record that there are certain prohibitions that are provided under K. Having said that, we have allowed the member of the public in, but this being a proceeding and you are not a party, you will not have the floor to speak or participate in any way in the proceedings. Having said that, if counsel for the State Bar can announce that.
Schnitzel followed all the rules but that she had to follow in order to bring this. So Schnitzel has not broken any laws or rules of the judge by posting this. She follows everything to a T because she knows that if she doesn't follow everything to a T, it could hinder anybody ever getting access again. So, just to put that out there. Schnitzel protects her ass.
Record.
James Lee, Senior Bar Counsel for the State Bar of Arizona. Present with me also Senior Bar Counsel Craig Henley.
Thank you. And then respondent.
Good afternoon, Your Honor. This is David Gingras.
Thank you. Okay, so Mr. Gingras has had filed a notice, and that's a notice State Bar's failure to comply with disclosure rules. That was filed on March 30th. The State Bar did file a request for clarification on response requested or required, and that was filed on April 1st. The disciplinary clerk did then issue the order setting this telephonic, and it was set pursuant to the rule that respondent had identified in his motion, and that is Arizona Rule of Supreme Court 58F3, which does require that the court set a telephonic within 5 days. Having said that, I did review your notice, Mr. Gingras, and I'll start with you. I'm not sure that I see what it is that you think is missing from what you described the State Bar has provided you. So can you enlighten the record?
Sure, Your Honor. So the issue deals with disclosure of Judge Mata's testimony. The State Bar has disclosed Judge Mata as a witness. What they have not done is disclose anything regarding the substance of her testimony. With respect to their specific allegations in the complaint.
Which is, it's just false. What he's saying here is just false. They have. He tried to pull this shit in the Owens v. Eckerd when it came to Maricini. And I don't know if he tried to pull it with Greg or not, which is interesting because I think they gave the same thing with Greg as they did Maricini. This is what Greg's testifying to. This is what Maricini was testifying to. Well, he might have tried to get Greg thrown out too, but really Maricini, because that was the only one he could truly focus on. But he's tried to make this argument about, they didn't tell me everything that these people were going to do. No, you just get a summary of what they're going to testify to. Just like, oh, Maricini is going to testify about the things in the forensic data or patterns or whatever. That's a good enough characterization because Laura knows what all that means. Just like if they say Mata is going to testify about this, the falsity or whatever, and what has happened from the fallout of those accusations. You know what those accusations are. You know what those statements are. You don't need anything else. And if you're going to depose them, just like you could have deposed Maricini, you could have deposed whatever. You want these people to have conversations with you or give you all this shit when they don't have to. Until they are told to, which I know is what you want here. But if the judge says no, you don't get it. You don't have a right to talk to people if they don't want to, unless the judge compels them to, or orders a deposition, or you get to cross-examine them or whatever. But he is very entitled in thinking that he is owed all this shit, and he is just not, and he is wrong on the law so many times. And I do not understand why dumbasses like lawyers and certain doctors, all they have to do is study and pass a test. And I get there's years of schooling and lots of money that goes into it. But I feel like there is so much more that needs to happen. And I know it's already hard enough to become these things. But I am starting to wonder if we should make it even harder. Let's get back to this.
That I made false statements about Judge Mata. The initial disclosure from the bar, which is on page 2 of my notice, says absolutely zero, nothing of any substance at all regarding these alleged false statements. They're not even referenced, other than to say Judge Mata will testify about the adverse impact of my posts about her. That doesn't tell me anything that she's going to say about, are these posts true? Are they false? There's nothing about the substance of her testimony on that issue. I then met and conferred with Mr. Lee about this. And as you can see on page 3 of my notice, the bar supplemented their disclosures to add at least something, which I've referred to as essentially a fair denial, that Judge Mata will testify that she didn't do anything that I accused her of. But then there's a really shocking, almost a footnote at the end of that paragraph that says bar counsel is attempting to confirm whether Judge Mata will in fact testify as stated. And I've characterized that as essentially admitting that Bar Council violated Rule 11 by making extremely serious allegations of misconduct against me without even talking to the only witness who could testify to that issue. So where we are right now, Your Honor, is we are days away from the dispositive motion cutoff, and I have not a single clue what the bar's star witness is going to say against me. And that's a clear violation of the disclosure rule.
You know exactly what she's going to say, that what you said was not true. And that what you said was unethical and is not how people should act. And that has negative effects on her. You know exactly. She's going to talk about your shit. He acts dumb. And he's not, well, I don't know what she's going to say. She's going to say you're a lying liar who lies. And that you sit on a throne of lies. And that you have no proof of anything that you say. You're ridiculous. Yes, love my replay crew. Yes, you need more sources to verify things. Also, as of right now, she's the judge that's hearing it. I don't know if she'll stay on it or not. Yes, lawyer, had the presidents, past presidents from Florida Bar on his show, and did a video about it. And it was very interesting. And I don't think that the way that Arizona does things is exactly like Florida. It sounds like maybe more people need to run their bars like Florida a little bit. I don't know. Florida's a bit crazy in itself, but it sounded like a great way. And I was wondering if some of that stuff is the same way in Arizona, but I'm thinking there's some different stuff because they kept talking about the Supreme Court and stuff. And I think the only time Gingras gets to go to the Supreme Court is if he goes to like appeal it. So that one was good. Yes, Megan Fox went over some stuff there. And that is in one of the next videos that's coming out that's going to be pre-recorded. All right. Let's get back to this so we can finish it up.
I have asked in my notice that you find the violation is willful and that you simply preclude Judge Mata from testifying. But that's not actually what I want, Your Honor. If you were to do that, basically that gives me a win, but a technical win. And I don't want a technical win. I want the truth to come out. What I said about the judge was unfortunately true. And I've been accused of lying about that. And there are no.
You just sit here saying, oh, it's unfortunately true. You have no proof that it is true. You've even admitted that she could have possibly gotten it in a non-nefarious way. But your brain automatically goes to nefarious because of your own life things. And because you do the nefarious thing. So you think everybody thinks like you. And they don't. Most of the world doesn't think like you. Thank God.
Now hundreds of videos on YouTube because this is a high profile case and somebody released the complaint. I didn't do it, but and I understand it's a public matter anyway, but all of these false accusations the bar has made against me are out online as part of social media. I'm entitled to vindication, and the only way that we can do that is by having Judge Mata testify and explain what she did and didn't do. And right now, we don't have any disclosure from the bar regarding that testimony. So what I'd like the court to do is to order the bar to tell me and to tell the court whether or not, first of all, whether or not Mr. Lee or anyone else has ever spoken to Judge Mata about this case. And then number two, if the answer is yes, what did she say? I'm entitled to that information.
Well, I'm not sure that I embrace your argument. Having said that, let me turn to the state bar. And so, Counsel Lee, because I'm assuming you're the one who's going to take the lead in response. It does not matter to me if it's you or Mr. Henley. But the notice, as far as what Mr. Gingras has just described, as far as the state bars providing notice with regards to Judge Mata and the testimony the state bar expects to elicit, is there anything that you disagree with regards to what Mr. Gingras has said or put in his notice?
Yes, it's state bar's position that the disclosure, including the supplemental disclosure, sufficiently provides Mr. Gingras with sufficient information to investigate and prepare his defense. His request for the information provided by Judge Mata to the bar is, in the state bar's opinion, work product, except to the extent to which he's going to testify. My experience has been that the court does not typically require opposing parties to disclose every statement that a witness is going to make while on the stand, but sufficient detail and categories have been provided to Mr. Gingras in the supplemental disclosure statement. So we believe that that is sufficient.
Well, I guess what I wanted to just make sure is, Mr. Gingras has injected certain portions of your pleadings in his notice. And so I wanted to just clarify, you're not suggesting that he omitted things that you think were controlling or relevant with regards to the question before the PDJ currently, right?
No, I believe, in fact, he has provided you with the entirety of the anticipated testimony that I included in the initial and supplemental disclosure statements.
And I will just note that with regards to the indication of bar counsel attempting to confer with Judge Mata, there are other pleadings that have been filed that does reflect that Judge Mata is being represented, and what those parties have, or that party has, or I guess she's not a party, that on behalf of Judge Mata, whether or not there should be testimony with regards to Judge Mata, and that's something that's not yet before the PDJ. So I haven't made any rulings on that for today's purposes. Mr. Gingras, can I just ask you, when we started the initial case management conference, I noted Civil Rule 5.2 with regards to the requirement that documents be filed in black and white. And in the document that you've cited, your notice that's before me right now, you've used color. Some of your other pleadings, you have used color, and it appears cut and paste, as we kind of discussed at the ICMC, being really more appropriate for an attachment. Can you tell me what's happening? Why?
So she's telling him, his color can be in like attachments, exhibits, but not in the regular document. Also, no, the reason that Gingras shouldn't have been involved in Mike's case or representing Laura in that one is because he is a witness. That's where the motion to disqualify Gingras came from. But Gingras wasn't on the case officially. And that's why Omar, Tilted Lawyer, was trying to say he should not come in and represent Laura Owens because he is a witness to the incident that she's trying to claim where he violated a restraining order, which is why he needed to renew it. But he is licensed to practice in California. Correct. If whoever stated that Laura got arrested during the raid, she did not get arrested during the raid. He's already been told about not using color, but he's like, but I do this for 20, 25 years, 22 years, and this is what I do. Well, you were told not to do it in this court, so you need to abide by those court rules. Maybe another court lets you, but this court said no, so stop it. But you're like, but I do this. It doesn't matter what the fuck you do. You're being told no. Let's see. Yeah, that is one of my biggest things about certain people coming on this case is I want the story to be shared because obviously it exposes stuff. It gets people to understand that there are women out here like this that men need to be weary of. And these type of women make things hard for real victims. But the problem with some people jumping on it now is because they want to do it while it's a hot topic. And if they're going to jump on it because it's a hot topic, I want them to do it right. And I think Bacon Bears, that's my opinion, is doing it right because she's looking at the documents and the videos. She's not just summarizing and spilling a bunch of shit. So she also, if she needs to correct something, she will correct it. But there are some people that are just putting shit out there and it's not accurate. And then it gets tied to us. Like we're just all the same. And it's no. Different individuals just supporting a specific cause. Yeah, do the research. But a lot of them won't put in the time to do the research because there's so much. And so they'll just repeat something they heard and they didn't fact check it. That's why when I do my videos, like even when I'm trying to summarize, I put in the receipts of everything I'm talking about. That way I have something that backs it up. All right, let's hear him explain why he doesn't know how to follow directions.
You haven't complied with my directive.
Well, Your Honor, I printed my notice. I have it on my desk in front of me. The printed version is black and white. I don't recall if there's color in any of the screenshots that are included, but this is an unbelievably common practice that I've used for 20 years. I understand the rule requires text to be black and white, but what I'm giving the court are illustrations or essentially screenshots that are just used to help assist the reader in finding information more easily. If you don't want me to do that, I will do it the hard way, but I've just done it this way for 25 years. And I've seen bar counsel done it that way. I've seen courts do it this way.
She's not saying you can't have them in there. Just say, hey, this goes with this exhibit. That helps the reader. They can look at that exhibit and be like, oh, okay, I know what you're talking about. It's not that hard. The hard way. It's not hard. You just put it as a separate attachment instead of where you want to in your thing. He writes his blogs the same way.
So I'm not trying to disregard the rule, and I certainly wouldn't disregard your order. If you don't want any screenshots and pleadings, just you can say that, and I will comply with that. But I have the document in front of me. It's black and white in the printed version.
Well, you may have printed it in black and white. I have a color version, and I will direct you to where it's in color in your filing, and it's on page 3. I kind of referenced it as being something that you were highlighting. The statement bar counsel is attempting to confer whether Judge Mata will, in fact, testify as stated. That is.
Oh, there's, yeah.
So,
Yeah, I guess there's highlighting there, yeah.
I'm not sure where the confusion is from our first conversation. That's the only reason I'm highlighting this. And so I'm not doing something other than enforcing the rules that exist. And so Civil Rule 5.2 indicates that in a document that it is to be in black and white. It specifically carves out the exception of exhibits or attachments. And so I'm not telling you can't use screenshots. I'm telling you need to comply with the rule if you want to present something that has color, for example, or has alternate fonts that are discouraged in Rule 5.2. But having said that, I've considered your request. I don't find that the State Bar has violated the discovery rules here or disclosure rules. And so your motion or your notice at this point, the PDJ is not going to take any type of remedial action because I don't find that the State Bar has done anything out of compliance with standard practice in disciplinary matters or pursuant to the rule. With that, we will stand in recess. Thank you all.
Your Honor,
Thank you.
I'm sorry.
Yes?
Your Honor, there are other issues we haven't discussed.
With regards to what was set for today,
Yes.
what else was set?
So the Judge Mata part was only one issue that I raised in the notice. The second issue, which is on pages, let me see here.
Mr. Gingras, what I asked you to do was to enlighten me if there was something in addition. And so you got to go first, and I asked the State Bar, did they have anything else? So I'm going to give you back the floor, but at this point, I will just reiterate my first query to you. So I have your notice. Is there something else that you wanted to address with regards to the notice that was set for today? Go ahead.
Yes, Your Honor. I didn't realize that you wanted me to address every single issue at one shot. I raised the Judge Mata issue first because I wanted to talk about it first. On page 7 of my notice, it says, in addition to this issue, meaning the Judge Mata issue, a second matter has arisen which requires immediate resolution by the PDJ. And then I'm explaining here that Mr. Lee is acting as bar counsel, but he's also the complainant with respect to multiple issues in the complaint. He's the sole complainant. And I've tried to speak to him about his allegations, and he's refusing to talk to me. So there's been no disclosure from the bar with respect to Mr. Lee's testimony. And in fact, he's obstructing my ability to investigate what he has accused.
I wonder if he's refusing to take a telephone call with you, which sounds like maybe they do, but they've emailed, of course. So they're like, he just won't talk to me. Make him talk to me, Judge. Nobody wants to talk to me ever. Ugh. So annoying. Jim Lee is not a witness. He is just the guy filing it on behalf of the State Bar. Just like you file things on behalf of Laura Owens all the time, Jim Lee is filing it on behalf of the State Bar of Arizona. That's how representation works.
Yeah, and no one else other than him has made those allegations.
When you say Mr. Lee, are you talking about Senior Bar Counsel Lee?
Yes.
Okay. Well, so I will just tell you it's the State Bar that's the complainant, not Mr. Lee. He works for the State Bar. So anything else?
So, Your Honor, so if I'm not able to investigate the allegations, I understand that Mr. Lee works for the bar. He is the person that I've been speaking with for the last 18 months. He is the one that has corresponded with me. I've responded to him. And based on our discussions, Mr. Lee is the person on behalf of the State Bar. But he is the one that has set forth allegations in the complaint that no one other than him has raised. So I need to talk to somebody to try to ask questions about what are you claiming exactly. And I guess I understand it's the bar, but Mr. Lee is the person at the bar who has this information. So if you're telling me that I'm not allowed to speak to Mr. Lee, that I can't present a defense, I mean, that's fine. You can take that position. Obviously, I'll seek relief from that.
Nobody said, nobody in that conference said you could not put on a defense. Well, if you're telling me I can't put a defense on and I can't defend myself, then okay, I guess I'll just get relief from it. Nobody said you couldn't defend yourself. But you need to defend your actions. God. He lacks basic understanding of everything. I can't comment on his nose because I have a big nose. I don't talk about anybody's noses.
I think you've mischaracterized even your own pleading. You're saying you just want to talk to Mr. Lee, counsel for the bar, but you've described him in your pleading as a witness. And what I'm clarifying for you, Mr. Gingras, is the idea that Mr. Lee is a witness is incorrect. So saying that you have a right to communicate with him as a witness in your proceeding is incorrect.
Well, I've disclosed.
I'll ask Counsel Lee to clarify. Have you taken the position that as far as in preparation for this proceeding, as counsel for the bar, you aren't going to communicate with Mr. Gingras?
No, not in a general sense. He asked me specific questions, which because I'm not a witness and I am only representing the state bar, I refused its work product information that he's seeking in the state bar's opinion. So I refused to answer some of the questions that he posed to me.
All right, Mr. Gingras, what else?
Apparently nothing, Your Honor.
Okay, and so that I don't run afoul of this the second time, and I'm assuming that the state bar doesn't have anything else that you need to put on the record before we disconnect.
No, we have nothing further, Your Honor.
All right, well, thank you, gentlemen. We will stand in recess.
Thank you.
Apparently not. I'm not getting my way. So I guess we have nothing else to discover because nobody's going to let me defend myself. Such a whiny little bitch. I don't know if Gingras has admitted to having his nose broke or something. Maybe he's gotten into some fights. Who knows? Maybe he played sports. Who knows? So that is, it's just, he sounds like my two-year-old grandson, whining when he doesn't get his way. So, that is going to be it for this live. Our merch site is back up and running. Memberships are back up. If you're a member, there is a discount code when you become one for 10% off merch. I only have one emoji now. If y'all have any ideas for other emojis that we might need, let me know. And then, of course, when we have more updates, we will put them out. I will be putting out the Harry Howe stuff because that is just funny. And the stuff that goes with the Harry Howe documents, because I'm missing a few documents we haven't gone over. So I'm going to do pre-recorded on those. And then let me see if it will let me. What is happening here? Like, for some reason, I can't. What is happening? Okay, I'm going to close out of that. Why does it keep. I keep trying to type and then it keeps doing a new tab. This is so dumb. I don't know what's happening. Because I was going to link. That's my opinion. Beacon Bears. Go look her up. Let me see if I can actually take it from here. Because I know they've linked to it. All right. Because I can put a link to her channel in the chat, and then I'll also put it in the description box. Also, if you haven't subscribed to Schnitzel Ninja, do that. Echoes, hey Rob, everybody. Okay, this one. Let's see here. Oh, wait, hold on. Okay. Here is the Beacon Bears reaction video. That is a good video. It's so funny because she is reacting the same way as we are, but she's just now hearing about this stuff. So her, like, she fits right in with everybody to me. Yes. Hey, Rob has been working on other things as well. Of course, there's Bruce the Moose and everybody. French Psyche also has a channel. If you want to go check that out. And then, but that's going to be it, guys. So I will see and talk to you probably very, very soon. And I hope that you have a good night, day, weekend, whenever you're watching. Love my replay crew, and comment down below. Make sure you're still subscribed and turn your notification bells on, because sadly, with the way with my schedule works, I can't always schedule way in advance for when I'm going to jump on a live. So you will need to know through the notifications when I do, so you don't miss an upload. But I will see y'all later.
Not pregnant at that time, and she lied